name is Jonathan Wilson, and I'm a partner here at the Atlanta law firm of Taylor English Duma. And welcome to this episode of Conversations with Ted, where we're going to talk about the Corporate Transparency Act and how companies' duties under that new law could conflict with certain state and federal laws involving data privacy. As I mentioned, my name is Jonathan Wilson, and I'm a corporate M&A and securities partner here at the firm. I'm also the founder of FinCENreport.com, a service provider that provides filing solutions relating to the Corporate Transparency Act. And with me is my partner, Mitzi Hill, who is also a partner in the firm. Mitzi, why don't you tell us a little bit about yourself and your privacy practice?
Hi, Jonathan. It's great to be here. And as Jonathan mentioned, I'm also a partner at Taylor English. I head up our data privacy and security practice. And I came to that through a long background in technology law and regulatory compliance. And so I work with our clients on figuring out what of the emerging morass of privacy laws apply to them and how to incorporate that into their business with a minimal sort of compliance impact.
Absolutely. So, Mitzi, I guess to frame the question, we're talking about the Corporate Transparency Act and how it can conflict with privacy laws. For those who haven't heard yet, the Corporate Transparency Act is a new law. It was passed by Congress in December of 2020. It hasn't taken effect yet because we don't have final regulations under the law. Those regulations are going to be promulgated by an organization called FinCEN, which is the Financial Crimes Enforcement Network, which is an agency of the U.S. Treasury Department. And once those regulations take effect, what's going to happen is that almost every private company in the United States, roughly 25 million of them, is going to have to file a beneficial ownership report with FinCEN. That beneficial ownership report is going to have to include specific items of personally identifiable information about all of the beneficial owners of the company. So, for example, if we had a corporation and Larry, Moe, and Curly were our three shareholders, for example, we would have to give these specific items of information about each of Larry, Moe, and Curly. And the specific items of information involved are full legal name, date of birth, home residential address, and then a unique identifying number, which could be a driver's license number or a passport number, along with a photocopy of that driver's license or passport. Now, these are all fairly sensitive items of information, the kind of information we ordinarily keep confidential because they can be used for identity theft. And yet this new law is going to require 25 million corporations to pull this data together, put it into a report, and then file that report with FinCEN so that FinCEN can share the information with law enforcement when law enforcement is looking for money laundering and other sorts of financial crimes. And so the question is, once this new law is implemented and corporations are pulling together this sensitive personal data, filing it with the government, are corporations going to have a conflicting duty under various state privacy laws? And Mitzi, that's what we were talking about. So tell us about some of those conflicts.
Well, it's a great question. It is an evolving question. That's probably the first thing and the most important thing to understand. Historically, the U.S. has not, at the federal or the state level, regulated privacy of personal data very heavily, except in certain vertical industries like healthcare. That is starting to change, and we are seeing a raft of state privacy laws that have been enacted in the last few years, the chief of which is in California. There are now 4 other states that have kind of followed California's lead in enacting what we call a comprehensive consumer privacy law. And these are intended to put an affirmative obligation on companies to keep certain information that they hold about individuals secure, confidential, and they are intended to require that the company interact with the individuals whose information they hold in certain regulated ways.
I certainly understand how in those states that have a comprehensive privacy law, like California, the corporation can have duties to customers to keep customers' personal information confidential. Does that duty ever extend to beneficial owners or investors in the company?
I think the answer to that is probably yes. I think this is a question that is likely to be tested because we're going to see increasing areas of conflict or tension between various US laws and these emerging privacy laws. But investors who are not employees, their information would certainly be subject to any of these state laws if the investor lives in that state. Investors who are employees, it will depend on the state, most likely, because starting in 2023, California's law is going to apply to employee data. And so employees will have the same rights and protections for their personal information that a customer would have. Other state laws may not extend that privacy protection to employee data. And so it will depend a little bit, most likely on the state in which the investor lives. It will depend on us not having a federal privacy law, and there are efforts pretty much every year in Congress to pass a federal privacy law. So if that ever passes, that would change the analysis. And then there are other sort of less prominent, less headline driving privacy laws already existing on the books in several states that apply to data security under certain circumstances, data security for certain industries, data security and reporting obligations in reaction to a data breach. And so each of those is likely to have some impact, not a big impact, but there is a wide net of laws that needs to be looked at to ensure that if you're complying with the disclosure requirements of CTA, you are doing so in a way that complies with the applicable privacy law, if there is one.
Gotcha. So I guess, still there's a lot of unknowns and it's going to vary from state to state, but I guess it's possible in some circumstances that a corporation could be obligated to file its beneficial ownership report with FinCEN under the CTA, but be subject to a contrary state law that says, corporation, you may not disclose this particular quantum of personal information to anybody without the consent of that individual subject. Am I getting that right conclusion?
That is basically right. It is for the state laws we have in the U.S., most of them do not require affirmative consent to regulatory type disclosures. They do require that you clearly notify the affected people that this is something you do with the information that you hold about them. And then that person would have the right to contact you down the road and say, what do you have? Who have you disclosed it to? That's wrong. Can you please correct it? Those kinds of follow-up actions. But for a purely legally required disclosure like this, you likely can make it. You just need to be sure that you have jumped through the appropriate hoops on the notice and disclosure side, and that you have a process for following up if any of those individuals want to know more about it later.
Yeah. And I guess because facts and circumstances can differ, companies are almost always going to need legal advice on how the state laws are going to apply to them.
I think this is a complicated enough area that is correct. The size of your company will matter. Where these people live will matter. The industry you're in may matter because there are multiple different levels of privacy rules, and all of the different facts have an impact on whether Law A or Law B or Law A and B cover what you're doing.
Gotcha. All right. Well, more to come as we stand by to wait for FinCEN's final regulations under the Corporate Transparency Act to tell us exactly how companies are going to file. And I guess there's also the law develops these various states that refine exactly what the corporation's confidentiality and privacy duties are to the different individuals.
I think that's right. 2023 is going to be a banner year because California's law is getting an upgrade, and these 4 other state laws that I mentioned are all going to take effect in 2023. So we're going to see a lot of change.
A lot coming up in 2023. All right. Well, Mitzi, thank you very much for joining me today. And thank you for watching this episode of Conversations with Ted, focusing on the Corporate Transparency Act and privacy concerns. If you have any questions or need legal advice, please feel free to reach out to Mitzi Hill or to me, Jonathan Wilson. And we look forward to seeing you again on a future episode of Conversations with Ted.